Hello, everyone. Welcome to tonight's lifelong lecture learning series. We're pleased to have with us Konstantin Starikov, Head of Access Services at Yale Law School. And tonight he's going to be doing a talk on the commentaries of the laws of England in Russia in the 18th century. So as you were admitted into the room, you were muted upon entry, and we just ask that you remain muted just to avoid any unintended interruptions. There will be time to have a Q&A at the end of this session. So we will lecture for a bit and then we will open it up to questions. You can either raise your hand or drop your questions in the chat, and I will try to help moderate that. And in the chat, there's also a link to our online evaluation forms, and we welcome any feedback that you have about tonight's lecture and any topics you suggest for future lectures. So without further ado, I'll turn it over to Konstantin.
Thank you so much. It's a pleasure to be here. Thank you to Framingham Public Library and Framingham State University for the invitation. And thank you for being here today. In this presentation, it is a presentation after all, but with no slides, unfortunately. So I'll just say that tonight we'll explore the fascinating journey of William Blackstone's Commentaries on the Laws of England as it crossed linguistic and cultural boundaries into the Russian legal tradition. Translating a foundational legal text, as you may know, is never a simple task. And in this case, it meant navigating not only the complexities of language, but also the significant differences between English common law and Russia's legal framework. We'll examine how Blackstone's legal philosophy was interpreted and adapted within the Russian context, the choices translator made in rendering key legal concepts, and the lasting impact this translation had on Russian legal thought. Through this lens, I hope we'll uncover how legal ideas travel, evolve, and shape systems of law across cultures. As Sarah said, if you could write down your questions, or if you could remember your questions, and then I'm happy to answer your questions at the end of the lecture. William Blackstone was an English jurist, judge, and legal scholar, best known for his seminal work, Commentaries on the Laws of England. Published in 4 volumes between 1765 and 1769, the Commentaries provided a comprehensive and accessible overview of English common law, making the complex legal system understandable to both legal professionals and the general public. In Great Britain, Blackstone's work had a profound influence on legal education and practice. Before the Commentaries, legal knowledge was often passed down through practical experience rather than formal study. Blackstone's systematic approach to law offered for the first time a clear and organized exposition of legal principles, establishing practically a foundation for modern legal education in England. His work helped standardize the teaching of law at universities, particularly at Oxford, where Blackstone himself was a professor. Now, across the Atlantic, Blackstone's influence was even more pronounced. In the United States, the Commentaries served as a primary legal text for aspiring lawyers and judges. American legal scholars and practitioners, including many of our founding fathers, relied heavily on Blackstone's interpretations of common law principles. His emphasis on individual rights, property law, and the concept of checks and balances resonated deeply in the formation of the American legal and constitutional framework. Even today, Blackstone is frequently cited in the US court decisions and legal discourse. Overall, William Blackstone's legacy lies in his ability to codify and clarify the principles of common law, shaping legal thought and education in both Great Britain and the United States for generations to come. Now, William Blackstone's Commentaries on the Laws of England had a more limited but still notable impact on continental Europe compared to its influence in the English-speaking world. Unlike Britain and the United States, most continental Europe countries followed civil law traditions based on Roman law, codified through comprehensive legal systems, like you probably heard about the importance of the Napoleonic Code. Nevertheless, Blackstone's work attracted the attention of European legal scholars, particularly those interested in comparative law and legal philosophy. We're talking about 18th century, so if we travel back to the 18th century, the so-called Enlightenment era. So in the Enlightenment era, Europe, there was growing interest in understanding different legal systems, especially the principles of English common law. Blackstone's clear and systematic presentation made the Commentaries a valuable resource for legal scholars seeking to compare common law with civil law. His emphasis on the rule of law, property rights, and individual liberty resonated with Enlightenment ideals influencing legal thinkers in countries like mostly France and Germany. Moreover, some European reformers admired the flexibility of common law as described by Blackstone. While they did not adopt the common law system, they certainly drew inspiration from its principles in discussions on legal reform and judicial independence. In Russia, the translation of Blackstone's Commentaries played a role in exposing Russian legal scholars and policymakers to Western legal thought, contributing to legal modernization efforts that mostly took place not in the 18th century, but in the 19th century. So let me give you a brief overview. The trajectory of Russian legal history from the 11th century to the late 17th century reflects the gradual evolution from customary and religious laws to more centralized and codified legal systems. It's important to know that in the 11th century, Russia, as we know it today, did not exist. Instead, there was a state called Kievan Rus, which was founded by the Rurik dynasty. This early Eastern Slavic state included parts of what are now Ukraine, Belarus, and Western Russia. And the people living there were a mix of East Slavic tribes, along with Norse settlers from the Rurik dynasty, that, as we now know them, the Norsemen, or the in Russians they call the Varyagi, the fighters of the north, for what's today's Finland, Norway, and Sweden. So that's where they came from. But at the same time, they adapted to the local culture, and locals, pagans at that time, were also influenced by the Byzantine culture and the Orthodox Church. So when Christianity was adapted in Kievan Rus, then laws and governance of that state became especially important. One of the earliest set of laws in Kievan Rus was called Ruskaya Pravda, Russian truth. And again, when I say Russian truth, it was more like Russian truth, right? Because it wasn't, as I said, there was no Russian, but again, Russian. And from a Russian perspective, again, a lot of times they call it Russian truth, Ruskaya Pravda. It was created around the 11th century and was mainly concerned with solving everyday problems like theft, property damage, and disputes between neighbors. Instead of prison sentences, punishments usually involved fines, meaning, let's say a person had to pay money as a compensation, even for murder. And the system focused on resolving conflicts rather than severely punishing wrongdoers. Religion, as I mentioned just moments ago about orthodoxy. So religion also played a big role in Kievan Rus law. The Orthodox Church had a lot of influence over how people behaved. Religious leaders helped set rules about family life, marriage, and moral behavior. If someone broke these rules, they might face penalties like fasting, public repentance, or even exclusion from religious ceremonies. So church law and secular law often overlapped, making the church also a powerful force in society. As the state expanded and developed, new legal codes emerged. And again, not going too much into the history, but if you are interested, going back to the 15th century, in some ways, long after Kievan Rus, fell apart, and the Grand Duchy of Moscow. So Moscow now appears, that's the future Russia. And Ivan III introduces something called sudebnik, which is a legal code that brought more structure to the court system. So judges now at this time in what is future Russia use this code to settle disputes through trials, often rely on witness testimony, a lot of times through physical torture, and oaths rather than concrete evidence. And of course, just like you can argue today, wealthier people manipulated the system, so justice wasn't always fair. In 1649, Tsar Alexei Mikhailovich, that's father of Peter the Great, he introduced a much larger legal code called Saborное уложение. And this code included hundreds of laws that governed nearly every aspect of life, from criminal acts to land ownership. While it aimed to organize society, again, Russia is centralizing more and more, it also imposes even harsher punishments, and now exile and execution are commonplace, and it's actually codified. By the time Peter the Great comes to power, this legal system is somewhat outdated comparing to the more structured laws of, let's say, Western Europe. Nevertheless, when Peter decides to reform his father's kingdom, declares himself emperor, Russia becomes Russia. So now his reforms modernize Russian law and bring it closer to European standards. But again, it all started with the foundations laid by earlier legal traditions. So that Russian legal system is not the same. It has its own separate, really, evolution from the Western Europe. Peter the Great's legal reforms of the early 18th century were part of his broader effort to modernize Russia and bring it closer to Western European standards. Recognizing the inefficiencies and inconsistencies of the existing legal system, Peter sought to create a more centralized, rational, and effective legal framework that would strengthen his control of the new state and support his very ambitious reforms, both in administration, military, and economy. So one of Peter's key legal initiatives was the streamlining of judicial administration. He established specialized courts to handle different types of cases, hoping to reduce the corruption. He introduced clearer procedures and oversight. He aimed to ensure greater fairness and consistency in legal decisions. He tried very hard. And the courts were increasingly subordinated to state authority, reinforcing centralized governance. So again, the idea of legal reforms in Russia was from top down, and the idea was to make things more efficient, less corrupt, but in such harsh and very in a way that was so strong-willed that unfortunately, as we'll find out, it didn't quite work. He also one of his reforms was the reduction of the church's legal authority, and that was really important because, again, we talked about the overlap of religious and civil laws. So now everything is separated. He established something called the Holy Synod in place of the old patriarchate. Essentially, Peter brought the Orthodox Church under state control. And this very much weakened the church's influence in legal matters, and particularly in family and moral law. shifting the responsibility to secular courts. I talked briefly about punishments. So punishments under Peter's legal system also reflected his emphasis on state authority and discipline. He introduced harsh penalties for crimes like tax evasion, desertion, corruption, believing that was his true belief that the strong enforcement was necessary to maintain order and ensure compliance with his reforms. However, Peter also encouraged what is very novel for Russia at that time is to use written evidence and testimony in trials, promoting what he thought at that time was a more systematic judicial process. So in the end, as we know, Russia did modernize, so that was a success. But the impact was mixed. On one hand, his efforts significantly modernized Russian legal administrative systems, but on the other hand, they faced limitations due to the vastness of the country. Russia still was very much entrenched in corruption, and the challenges of enforcing laws across a largely rural and illiterate population was a huge challenge. So again, briefly, his successes were that there was some success in codification, and I would say that his legal reforms, reinforced the authority of the central government, contributing to a stronger and more unified state. But at the same time, the effectiveness of these reforms were often undermined by, as even today in Russia, by persistent corruption and the lack of qualified legal professionals. So many local officials continued to abuse their power, and the state really struggled to ensure the fair application of laws, especially in remote areas. So on top of it, the harsh punishments and the authoritarian nature of Peter's laws, maybe well-intended, but it actually fostered resentment and resistance among the population. So in short, Peter the Great's legal reforms were successful in modernizing Russia's judicial and administrative framework, but they fell short in creating a fair and equitable legal system. Let's see. So I'll just say briefly about what happens after his death. So Peter dies in 1725, and of course, nothing stands still. The evolution of the Russian legal system continues. It's not as significant, although his wife and his daughter, who basically inherited the power, they tried to introduce they introduced new laws. They tried to codify things, centralize things, and make it more in tune, sort of what Peter was trying to do. And as early as 1729, there was an initiative to consolidate existing laws, but it didn't quite happen. So a lot of times regional courts continued to rely on outdated codes like the ones that I mentioned from 1649, Соборное ложение, and a lot of times local laws were still somewhat like in England, were based on the interpretation of local customs, and it didn't quite work. On top of it, they were trying to modernize the army, so they introduced something called military articles, and again, doesn't quite work for them. Regulations governing the civil service are refined. They impose stricter accountability on officials, but again, these laws served primarily the interests of the state, didn't ensure the justice for ordinary citizens. Also, maybe some of you heard that at this time, Russia actually is becoming, unlike Europe, more and more entrenched in the feudal practice known as serfdom. So the legal system also reinforced the institution of this system, meaning that peasants were more and more treated like slaves. And laws during this period increasingly restricted the rights of of the majority of Russian population, because the majority of Russians were peasants, and these laws granted landowners more and more extensive control over their serfs, and courts often favored nobility in legal disputes, further entrenching the social inequality. So then the next, again, skipping, if Catherine the Great. So Catherine the Great, again, we don't have a lot of time to go in details. If you're interested in sort of how Catherine the Great came to power, Framingham Public Library has lots of interesting books on that topic. But Catherine, who was a German princess, right? She ascends the throne in the way that some of you may know wasn't legal in a sense. It was an overthrow. So she had to figure a way how to legitimize her position, and she also was a child of her time. So she was brought up in the during the period when Enlightenment was really influential. So she became someone who was really invested in modernizing Russia even further, right? So she, let me just admit this person, I apologize. Sarah, there's someone who's in the waiting room, I think. Okay. So she acknowledges that Russia that now she has to govern, that she's still very inefficient, that the bureaucracy is she has to deal with that, the legal fragmentation of the codes, the social inequality. So she recognizes these challenges and soon embarks on her ambitious legal reform efforts, seeking to create a more rational, codified legal framework inspired by these Enlightenment ideals. And when we talk about Enlightenment, of course, Enlightenment thinkers had a profound influence on the European legal system by promoting ideas of reason, justice, equality, and individual rights. Of course, during the 17th, 18th centuries, philosophers across Europe start to introduce these modern ideas where they criticize arbitrary rule, harsh punishments, and outdated legal practices. Philosophers like John Locke, Jean-Jacques Rousseau argued that all individuals possess natural rights, including life, liberty, and property. They believe that law should protect these rights rather than serve the interests of the state. And this emphasis on legal equality influenced the development of constitutions and legal codes that established the rule of law as we know today in the Western world. And of course, if this all sounds very familiar to you, yes, our founding fathers were very much recipients of this experiment, really. So all these ideas, for example, the work of Montesquieu, the spirit of the laws, now advocates for the separation of powers within the government. We know today in our constitution, legislative, executive, and judicial branches. Another important thinker is Italian, Cesare Beccari, on Crimes and Punishments, published in 1764, condemns torture and the death penalty. So again, if you remember, I talked about sort of the commonplace of using torture for getting some sort of evidence or witness, getting out of the witness some sort of factual information. Again, not to say that in other countries these type of practices were unknown, but certainly these changes are happening a lot faster in Western Europe, whereas in Russia, it's still it's different. So and a lot of kings like Frederick the Great of Prussia and Joseph II of Austria, now they become these enlightened kings, right? Where they are also centralize their governments, but in a way they want to rationalize everything, right? So it's the idea of introducing legal reforms that simplify laws so that your citizens, and again, the idea of a citizen, that they follow these laws, that they understand what the laws are. So all these things that were happening in Europe really influenced Catherine. And she recognized the potential for the ideas to strengthen her rule and to modernize Russia further. And she was very ambitious. She was very intellectually engaged, and her goal was to elevate Russia's standing in Europe. And she believed that adopting these Enlightenment principles could improve governance, promote cultural development, and enhance the well-being of her subjects. So the long story short, it didn't work, right? It didn't work, but and we'll get to why it didn't work. But it's interesting, especially now, to understand, like if you follow the sort of the current state of Russia today, and how knowing and sort of knowing what it went through in the 20th century, the Soviet Union, and how the totalitarian states also used legal systems sort of to not so much focus on the individual liberties and the well-being of its citizens, but again, the emphasis is on the state. The real unique situation in the 18th century is that it actually coincides where the Enlightenment ideas that we just talked about and the desire to strengthen the state, they coincide. So for a moment in Russian history, there's that hope that, yep, there's a chance to become maybe just like England, or maybe just like France, or just like, so they are pretty much in Catherine II, the Great, as she was later known. She's thinking about Russia as a European state. So more and more Russia is on a path to integration with Europe. So it is in this historical context that Catherine the Great requested a translation of William Blackstone's Commentaries on the Laws of England. She saw it as a valuable resource for understanding legal principles and improving Russia's legal system. And her interest in Blackstone's work was driven by her broader goals of legal reform and administrative modernization and the application of Enlightenment principles in governance. So what do you do? So the first thing is to translate his work into Russian. And the Russian, so she commissioned a scholar, a Russian legal scholar. His name was Semyon Desnitsky. So he has a very interesting background. He was born in 1740. He studied at the Moscow University. And he, in 1760, so he was only 20 years old, he was sent abroad as part of the government program to educate young Russians in Western European universities. So he ends up in Scotland. He studies at the University of Glasgow in Scotland. And he attends lectures by famous philosophers like Adam Smith. So he very much is influenced by the British lifestyle, by the philosophers like Adam Smith. And then in 1767, he returns to Moscow and he becomes a professor of law. He basically becomes an advocate and he proselytizes English common law principles. He advocates for reforms based on, inspired by Western legal traditions. So Catherine certainly, had someone already who would do that kind of work for her, and she asked, she didn't ask, she told him to translate this work into Russian, although she already had access to this work, all 4 volumes in French. So she was reading in French, but again, as a way to modernize Russia, to translate these ideas from English to Russian, the work is commissioned to Desnitsky. So Desnitsky translation of Blackstone was not a simple word-for-word rendering. Instead, he adapted the text to address Russian readers, right? To suit Russian readers by explaining concepts that were unfamiliar to society, where there was very little. There was no tradition of common law as it existed in England. And his translation introduced Russian legal scholars to the philosophical foundations of Western legal systems, that in a way that for the first time it balanced state authority with the protection of individual rights. And it's interesting to consider what kind of challenges he faced. And here's some examples. So challenge number 1, I thought, is sort of the conceptual differences in legal systems. Blackstone's text relied on concepts like common law, precedent, and trial by jury, for example, which were central to the English legal system. Russia, however, followed a more autocratic and codified legal tradition without the principle of judicial precedent. So Desnitsky's approach was to provide extensive explanatory notes to contextualize these concepts for Russian readers. And in some cases, he offered comparisons to Russian legal practices to make the unfamiliar ideas more understandable. Just to give you an example. So to translate trial by jury, Desnitsky used the term суд присяжных. And this term directly means court of assessors or court with jurors. Since Russia did not have an equivalent practice, the term itself would not have conveyed the full meaning to Russian audience, even if it was, as he was looking for something that is of the nature of the word jury, for example. So recognizing this, Desnitsky supplemented the translation with detailed explanation. So, for example, he described the jury as a panel of, again, translated into English as respectable citizens, добропорядочные граждане, who were chosen to judge the facts of a case. So he emphasized their role as impartial decision makers, tasked with determining guilt or innocence based on presented evidence, a principle, deeply rooted in the idea of civic responsibility. So again, for Russia, that was a complete novelty. Furthermore, Desnitsky clarified that the jury's function was separate from that of the judge, who oversaw legal procedures and ensured the trial followed the law. And this distinction was also unfamiliar in Russia, where judges typically held complete authority over both legal interpretation and factual determination. So although Catherine's legal philosophy, as she, and this was an outline, so it was never actually implemented, but as it was outlined in her instruction called Nakaz of 1767, she is, she is emphasizing, she's really trying hard to be fair, to rationalize legal procedures, to introduce this concept of the rule of law. But at the same time, she was not a strong proponent, for example, of trial by jury in the way that it existed in England. So while she was influenced by Enlightenment ideals and sought legal reforms to modernize Russia, in many ways, she remained a firm autocrat who continued to prioritize state control over judicial processes. And of course, if you think about it, there's some logic behind it. For example, Catherine feared that the jury system might weaken the government's ability to control legal decisions. She felt that it would place power in the hands of ordinary citizens rather than trained officials that are loyal to the state. And given the structure of the Russian society of that time, it was quite different from the society in Great Britain. It was deeply hierarchical. It was dominated by the nobility. And as I mentioned, the vast majority of the population were serfs. So Catherine likely saw trial by jury as impractical because Russia lacked an educated middle class capable of serving as jurors. In her way, it was within the logic of enlightenment. If serfs were illiterate and and they most likely uneducated, most likely they would be irrational rather than rational. So it conflicted with her goal of rational governance. And another challenge that I thought would be interesting to point out is the absence of equivalent legal terms. So many legal terms that Blackstone works mention, such as equity and habeas corpus, had no direct counterpart in Russian law. And Desnitsky, again, approached this in a way so that he resorted to descriptive translations. He, for instance, introduced the principle of habeas corpus as something as a, quote, a demand for the bodily presence of the arrested person. And this phrase, again, maybe was not as clear to the Russian reader. So again, to ensure more clarity, he explained that habeas corpus served as a legal safeguard to prevent arbitrary imprisonment by requiring judicial oversight. And he quite, bluntly contrasted this with Russian legal practice, where imprisonment often occurred without any formal justification or the possibility of appeal. The other major difference, and which was a challenge for Desnitsky, was trying to explain the difference in property law and land rights. So, for example, the English property law was highly developed, as we know, and Russian property law was very much dominated by serfdom and the near absolute authority of landlords, rather than by various forms of land ownership and inheritance. And again, it was hard to translate these concepts of, let's say, freehold or leasehold that Desnitsky again tried to come up with a somewhat similar expression, and then he had to rely on these descriptive, tricks, if you want to call it that way. And a lot of times it would be very, very long descriptive insertions. So in that way, the Blackstone was not the same, right? It wasn't, as we said, it wasn't word for word translation. And also, for the first time, like, for example, he introduces these words that now will become part of Russian language. So, for example, the word собственность for, property ownership. So, he tries to describe something which is, again, doesn't really exist in Russia, for example, in terms of inheritance or the property transfers. For example, in English law, there's inheritance is by the eldest son, whereas in Russia it's among all sons. He also carefully explains how English legal principles differ from the Russian traditions. So that, for example, he tries to explain what are English nobles. So in a way, also it's an introduction to this quite very different world of Western Europe, and especially of the social social structure of Great Britain of that time. Finally, I would say the challenge that he had to find a way to I mean, I don't think it was actually solvable, but in some way he had to translate the philosophy itself, right? So Blackstone's work was not just a legal textbook. It was a philosophical defense of the English legal system, right? So it was Blackstone's emphasis on the rule of law, on natural rights, that really clashed with the autocratic political structure of Russia, right? So the challenge was, how do you translate that, right? How do you translate that and present it to Catherine the Great without actually offending her, right? So that was quite a challenge. And in my opinion, he actually found a way around it. So he again finds these ways around to talk about the rule of law, but he uses, for example, Russian words that reflect the concept of autocratic power. Like, for example, he talks about the power, власть, the power of the law. And again, this kind of inability in some ways to really understand and actually use the language for what we take for granted, like the rule of law, right? It seems so simple. But at that time in the Russian mind, it was the power of law. And for those of you, again, who follow what's happening in Russia today, even before the war in Ukraine, Putin, for example, a lot of times refer to a so-called dictatorship of law, right? So in that sense, the concept of the rule of law was never adapted in Russia as we linguistically, at least the way that we understand it. As we know, language influences our perception of the world, and in some ways it can be said that for example, words like the power of the law or the dominance of the law that Desnitsky used in some ways formed the legal philosophy of Russia. Let's see, it's 7:44. So I think I'm just gonna mention if one more thing that I think is very interesting. And it's really hard to explain. I mean, for those of you, I don't know if anyone speaks Russian, or maybe you studied Russian, or those of you who speak other languages and you appreciate the challenge of a translator from perspective of language and style. The challenge for Desnitsky in the 18th century was that at that time there was no literary Russian language. It was still forming. And he himself actually, by participating in this historical period, his translation itself is part of this process of evolving towards the Russian language, Russian literary language as we know today. The challenge also was that Blackstone still even today is known for his eloquence, right? For his brilliant style. And translating that, I'm sure it was very, very challenging for Desnitsky. Nevertheless, Desnitsky simplified and was able to find ways to sort of to simplify the language, but also to elevate it, right? So to keep this grandiose style. And this mixture of elevated style, conveyed by this gravitas of legal discourse, at the same time, very, with much emphasis on clarity and precision, was quite an accomplishment. So I think Catherine the Great really appreciated that. And again, without going to linguistic analysis of his text, we can talk about sort of how similar his style was to the 18th century style of other Russian writers of that time. But it was certainly I would say a mixture of Russian vernacular language, which made it accessible to educated readers. There was just enough borrowings from Latin, French, and English legal terminology. So for the first time, actually, these terms are introduced into Russian language, like the word criminal, so криминальный. And also, it created a foundation for the future legal language in Russia. So a lot of terms actually that Desnitsky introduced as these, stylistic and linguistic experiments, they actually stayed. And the word like punishment, for example, преступление. Before that, there were all these different legal terms for punishment. I'm sorry, punishment. Преступление. So преступление is crime, just like in Dostoevsky, crime and punishment. So преступление, наказание. So, for example, even in this well-known Dostoevsky book, these words are, you could say, were influenced by the 18th century and by the work of Desnitsky. So to summarize or to end, I would say that through his translation, Desnitsky not only introduced Blackstone's legal thoughts to Russia, but also enriched the Russian legal lexicon, and he contributed to the formation of a more sophisticated legal language. And his work in Russia today remains really a testament to the intellectual exchange between Russia and Western Europe during the Enlightenment. So I hope you, and I apologize if it was too long, but happy to take your questions, and thank you so much for your attention.
Konstantin, we do have a question in the chat from Gary. He says, as you describe Catherine the Great as an autocrat in trying to modernize society, can you make a comparison to modern American history of current administration transitioning from an enlightened society to an autocratic / oligarchy rule?
Yeah, I mean, history works in interesting ways, and in some ways, it can be reversed, so that again, if we move away from these 18th century Enlightenment ideas, very much which are solid. I mean, our Constitution, American Constitution, is the best example, right? I mean, if there's no separation of powers, then basically you end up with this desire to, or claim to, to have the rule of law, but in the end it may become not the rule of law, but the power of law, right? So the law will be there no matter what, right? So, for example, autocratic states like Nazi Germany and Soviet Union, I mean, they had very vibrant and evolving legal systems. So it just that it worked in favor of the state, not in favor of the individual. So yeah, I would say that and again, I've lived in this country for a long time, so I'm an American. So and I feel that it's just very strange to see all these things that I talked about today. I mean, in 2025, that go back to the 1700s. So I guess history repeats itself.
Anyone else would like to ask a question? You can either drop it in the chat, or if you want to put your hand up or just unmute yourself and ask, feel free to do so at this time.
And also feel free to, for example, if you like to share if you like to share something about Catherine the Great or Peter the Great. And again, I try to make this less politically charged, but again, I'm just like Gary, is the question. I mean, I'm open to making contemporary comparisons, and yeah, so feel free to do that.
Do you want to take these questions? We have one from Isabel. How did the development of jury trials in Russia differ from their development in England?
Well, it took them actually a long time. So it took them another 100 years, maybe more. So I mentioned Dostoevsky. So Dostoevsky was a witness of the evolution of the Russian legal system. And he was very much, all his works, Crime and Punishment, Brothers Karamazov, actually reflect on these changes in Russian society at that time. So it is with the breakdown of that system. So the trial by jury was introduced in 1864 in Russia, and this was quite novel. And a lot of people, even like Dostoevsky, who's very conservative, they were very skeptical about this. And but it only happens because of the repeal of serfdom. So in 1861, serfdom was repealed by Alexander II. And again, he, just like Peter the Great and Catherine the Great, and Alexander he was Alexander II, not the Great, but he actually was doing very much the same thing. He was trying to modernize Russia, and such major reform was a legal reform. But again, unfortunately, it lasted only for a very short time. And but so when after the Bolshevik Revolution, that didn't exist anymore. And even today, I mean, there are trial by juries, but mostly it is the state and the judge, again, sort of in that position where they pretty much interpret and decide, and it's kind of back where they started. So I would say that it was a very short experiment, but it wasn't, unfortunately, wasn't as successful, and for different reasons. And even today, there's more work to be done.
We also have another question. It says, when did Moscow become the capital versus Kyiv?
Right. So again, I mean, if you listen to Putin, then Kiev was capital of Russia in the 11th century. If you and again, I myself come from Ukraine, and I speak Russian. I grew up in Eastern Ukraine, so sometimes it's a matter of pronunciation. Kiev or Kyiv. Kyiv. Kyiv was not the capital of Russia. It was the capital of Rus. and Moscow was a very small village. So when the Mongols conquered this huge territory, including what's today's Russia, Ukraine, part of Poland, they pretty much destroyed the Kievan Rus, and then a lot of these tribes that tried to escape went up into the forests to the north, and then starting about 1400s, they started to consolidate, and Moscow started to become a city, and then they became the Duchy of Duchy of Muscovy, and Muscovy became Russia, and today's then the Soviet Union, then the Russian Federation. So again, from a Russian sort of classical Russian perspective, Kiev was the capital of Russia a long time ago, but from a from a Ukrainian point of view, it was not. So so it still is. Unfortunately, it's not just history. People actually dying today because of all this historical disputes, so to say.
Well, I want to thank everyone for coming in and joining us, and I want to thank you, Konstantin, for having your lecture with us today. And we hope to see you all back again for our next set of lectures in April.
Thank you so much for your time.
Take care,
Thank
everyone.
you.
Have a good night.
Thank you.
Thank you.